at all, please feel free to keep your camera off. There will be a presentation and then time for discussion and Q&A after the presentations have taken place, but we will keep things as normal, tight to the hour, because we're aware of how precious everybody's time is. As ever, please do use the chat box and record any thoughts, comments or questions that you have and don't want to forget. And most of you will know me already, but for those who don't, my name is Catherine McWilliam and I am the Scotland Director for the IoD, or Institute of Directors. And I think just one of the things that I wanted to throw out there before the conversation started today is that this is something that we are seeing increasing demand and questions around. I think I've been quite struck, just over the course of the past year, the number of members who are reaching out for advice, guidance and signposting around the prospect of potentially needing mediation and wanting to understand a bit more about what that is and what that entails. So it's lovely now to have Graham and Rachel who are going to talk us through exactly that and demystify it. So if it's okay with everybody, I am going to hand over to Graham and Rachel and keep quiet. Thank you all.
Okay, well, thank you very much for inviting us, Catherine, and hopefully people can see the slide that I put up there, which is just repeating the title of the session. It's great to be able to speak to you all, and hopefully through what Rachel and I are going to discuss, we'll be able to give you an insight into how mediation can help business in Scotland. I'm just looking to, there we go. So looking to try and help you to understand what mediation is and how it works, outline a little bit about how it's used in Scotland, and then look at how you might be able to access mediation. This is a graphic I use when I'm doing seminars on mediation skills training, and it's sort of a bit of a commentary on conflict, because back in 10,000 BC, conflict was often represented by people clubbing each other over the head, whereas now a lot of the conflict seems to me to be happening with keyboard warriors and communication, which is happening over the internet. And it's maybe just a reflection on how things change, but certainly some of the stuff that I see that I've mediated, it's amazing how much of conflict can be exacerbated by the communications that people have around whatever the issue is. It's also something about conflict that very often you'll have two people who'll be looking at exactly the same thing and see something completely different. And one of their jobs that a mediator has is to be able to help people to understand that somebody might see something which you think is absolutely one thing as maybe something else. Because it's very much about the perspective that people take. And so, as I say, that's one of the jobs of a mediator, is to help people go through that. When I was thinking about business, I was reminded of a survey that the CIPD, it's not the CPID, the CIPD did, the Chartered Institute for Personnel and Development, and they did a big workplace survey a couple of years ago. And they found that at least 4 in 10 will usually face conflict, and that's usually with their manager, that it impacts on stress, motivation, and commitment, and that as a result of conflict, it's around 1 in 10 people will leave an organization. And if you're running an organization, I'm imagining that, and certainly I know from our own organization, is having to replace somebody who's a valued member of your team is a very expensive thing to do, and is potentially a very destabilizing thing for an organization. It certainly takes up a lot. I know when we recruit somebody, it takes up a lot of time to be able to bring somebody in and bring them on board. So if you're able to resolve that conflict, that's a big potential bonus for your business. The Chartered Management Institute also had a piece around difficult conversations. And one of the things that they quoted was that Brits find it harder to ask for a pay rise than they do to dump their partner. And that again said to me something about the difficulties that people have and how they're able to express themselves, and why sometimes people need a bit of a hand when they're wanting to talk about something with people. They said that the three top things that people had difficulty talking about in the workplace were things like pay, colleague inappropriate behaviour, and feedback on poor performance. And that as a result of some of those issues, that 66% will get stressed or anxious. Now, I know there's been a lot of talk recently around mental health, whether it's real, whether it's not real. I think the point I would say would be that if you've got people who feel that they're stressed or anxious, that's something that you want to think about how you can resolve as a business. And if mediation can help in that process, then that's something that could be useful. The sorts of conflicts that Scottish mediation tend to see around business tend to be in four main categories. There's ones which usually involve the business and the employee, and I would say about at least half of the mediators who are on our register will deal regularly with employee and business conflict. Quite often, if you can resolve those conflicts early, then you're not facing things like employment tribunals, grievance procedures, and all of those things which tend to push people apart. It's also the case that there's an ability for directors, boards, and CEOs to fall out with each other. And sometimes mediation can help in those situations as well. One of the big ones, I think, is often business to business. And that can often be a dispute around contracts. It can be somebody's not paid. And in Scotland, depending on the size of those types of disputes, it can be very expensive to try and resolve those disputes. And certainly I know from conversations with a number of businesses that often people might look at the sum and go, do you know what, if we have to have a lawyer, the other parties represented, even if we win, we might not win. Let's just write this off. And I don't think that's a satisfactory situation for people when there may be some other opportunities to be able to resolve things. The other one is, of course, business to consumer. One of the things I do as a mediator is I do work on the Edinburgh Sheriff Court where I look at simple procedure cases. And it's amazing how many of those cases that we will resolve just by helping people to have a conversation and understand each other. And it's usually not about what it's written down on the court papers. There'll usually be a human relationship where somebody has disrespected somebody, ignored somebody, or not listened to somebody. And that's been a result of what's happened there. In terms of what mediation is, it's a form of dispute resolution. Parties come to it willingly. It's not something that tends to work well if you force people to try and come to an outcome. Now, there's a discussion going on about how much of a prod you should get within legal processes to come to mediation. But certainly there's no way you would force anybody to go and agree an outcome in a mediation. It provides a useful confidential space for discussion, and that can give people an opportunity to get a better understanding of where people are coming from, knowing that what they say in the mediation is not going to be repeated outside the mediation. It's helped by the mediator not being a party to the dispute and being independent. And then also, I think the big strength for me in mediation is that it's the parties who control the outcome. And often that can lead to an agreement which you wouldn't get from other forms of dispute resolution. That might be an apology. It might be a whole number of different things. It usually will involve money if it's a court dispute, but all sorts of possibilities are opened up in terms of how you resolve the dispute. Traditionally, you'll have the mediator who will be mediating and party A and B. That can be in a room, it can be online, it can be in separate rooms, and it can be a whole combination of all of those. One of the things that we found is that mediators are being used more and more where there's multi-party involvement and also sometimes involved in group facilitation. I certainly know that a number of the universities have in-house mediation systems where they've trained up people within the university to be mediators. And I know one university where simply through a group facilitation, they were able to resolve a massive dispute within one department. The fact it was the physics department and the physicists weren't necessarily recruited because of their person-to-person skills, just somebody coming in who wasn't part of the department to be able to help them see how things were was a big positive. So mediators do a number of things in the process of mediation. They'll facilitate a conversation. They're very big on listening and asking questions. They'll reality test what people think about the dispute they're involved in. They'll also work very hard at getting the parties to communicate effectively with each other, and they'll use a number of different techniques to do that. And from that process, they'll seek to find where consensus exists between the parties and seek to build on that. My colleague uses a pyramid discussion, a bit like icebergs, where the points of dispute are often very far apart. But once you talk to parties about what their needs are, you begin to get to a discussion where actually you'll find that there will be some form of common ground where people are able to move forward. In terms of the process and how it works, usually there's an agreement to mediate, which is written down. And you might get to that place by having separate conversations with somebody who either knows about mediation or is indeed the mediator. Once a mediator is appointed, they'll usually speak to the parties separately just to get an understanding of the dispute and to be able to reassure the parties that they're the right person to do this dispute. There'll be some form of mediation session. And as I say, that can be online or in person, which hopefully then leads to an agreement. Certainly, if you look at the statistics for something like the Sheriff Court, it's somewhere between 80 and 85% of the cases tend to end in agreement. And that then means that that's out of the court, parties have settled and that they can move on with things. In terms of why mediation works, the focus is on the parties and what their needs are. Agreements tend to stick because it's something that people have agreed to. One of the things that shocked me when I first came into post in Scottish mediation was I was looking at what was then small claims in one of the sheriff courts and talking to one of the in-court advisors for citizens' advice. And he explained to me that out of the disputes where the sheriff had made a ruling that the parties would do X and Y, somewhere in the region of 40% of those were never fulfilled. And one of the reasons, in his view, for that was because it was something that was imposed on them. It wasn't something that they'd come to an agreement on. And as I said also earlier, it can take into account issues that an adjudicative process wouldn't look at. So that's around feelings, it's around how people communicate with each other, and what might help to satisfy those things. It has advantages in that it's confidential. The court process can be lengthy, and there's often a disproportionality of costs involved in using courts, which I think mediation helps to resolve to a degree. It can be useful for restoring relationships. And the prime one is that we try and help parties to focus on what does the future look like and how do they want to move forward. It won't be appropriate in some situations, and that's usually where there's been a criminal offence committed. If we hear something of that sort, we would usually be looking to say to the parties, look, you need to resolve that before you even think about coming to mediation. If it's an issue which is beyond the power of the parties to control, it's only happened to me once, because one of the questions that you are always asking in mediation is, do we have the people in the room who would need to authorise an agreement? And in one instance, despite the parties having said that, we'd reached an agreement. It was a landlord-tenant dispute, and suddenly the agent for the landlord phoned the landlord, and the landlord, on hearing what had been agreed, said, "There's no way that's happening." Now, mediators are impartial, or should I say, they manage their partiality. But once that happened in that conversation, I was dying to hear what happened when the case went to court, because at the end of that process, I'd suddenly taken a side, which you wouldn't do during the mediation. But as a result of that, I wasn't too impressed. The other aspect is you do need both parties who want to mediate. it's sometimes the case that there might be an initial reluctance, and by speaking to a mediator, parties can be reassured about the process, because it may be that somebody thinks the process is going to do something that it's not, or that there might be a demand put on them that isn't. And so we often find that given the opportunity to speak to people, once they've had an understanding about what mediation is, then they're quite happy to proceed. So in terms of Scottish mediation, we're a professional body for mediators in Scotland. We're not quite as established, say, as somebody like the Law Society, in the sense that in order to call yourself a mediator in Scotland, there is no legal obligation. You don't have to have a standard. So that's the reason that we formed a body of mediators and have our own register, so that people can have an understanding that the people who are on that register have particular qualifications, have appropriate insurance, and also, as our body, should something go wrong, that people can come to us in order for us to be able to support them. There's a series of standards that we use, and one of our big jobs that we do in Scottish mediation is to promote the use of mediation. As I said, we've got a Scottish mediation register. There's about 80 mediators on that just now, and they deal in a variety of different types of disputes. There's also family mediators who work via the Law Society and Relationship Scotland. And then there's also community mediators who tend to resolve things like noise and neighbour disputes, and they're often based in local authorities. So the last count I did was there's about 300 active mediators in Scotland or so. The register sets out a code of professional conduct and the standards of practice that we would expect from mediators. And one of the things to say is that as a body, if you are looking to have a question about mediation, we operate a public helpline. And the purpose of the helpline is to be able to answer questions, but then also to be able to connect you with a mediator, or to give you resources that you could go and find your own mediator yourself. In terms of trends in Scotland, the pandemic changed everything. Nearly 100% of mediations prior to 2020 were in person. There's been a move back to in-person mediation, particularly for more high value cases, but certainly for convenience sake, most of the mediations that happen, say, in the Sheriff Court and Simple Procedure, which is up to £5,000, are happening online, which seems to work well for the parties. It's slightly different for the mediator, but it's like anything else. Once you get used to it, it's not too bad. There's also a bit of a mix and match where people are using a bit of online, a bit of in-person, and they might use, say, online for initial conversations, but when they bring the parties together, that might be in the same room. There's also an extent to which people like government and other bodies are seeking to use mediation as part of a wider policy approach. I know certainly that some of the discussions around net zero, where you bring a wide range of stakeholders into the room, have been using a facilitative mediation type of approach, because it's very easy for people to say, yeah, we're all for that. But as soon as you get in the room and you actually start getting into the nitty-gritty of some of the issues, sometimes people need a bit of help. So that's my section. It might be best maybe to take the questions once Rachel's presented her thoughts, because Rachel's going to concentrate on some of the insights that she's got from some of the cases that she's done. So I will stop sharing and over to you, Rachel.
Thank you, Graham. So let's just make sure I can everybody see those slides? Good, okay. So yes, so thank you everyone for having me along today, and thank you to you for coming as well. So I'm going to build on what Graham has said about providing some practical insight into how mediation can help businesses. And if everyone's up for it, I'm going to ask for a little bit of audience participation at the end. So nothing to worry about, don't worry. So just briefly, I mediate a broad range of disputes, from high value litigated commercial claims where mediation is used as a settlement tool, to boardroom, organisational and workplace conflicts where the objective of the mediation is to preserve or restore the working relationship. Conflict is inevitable in every part of a business, whether you have a dispute with a supplier, a customer, a professional advisor, an internal conflict on your board, as Graham has said, with your shareholders, whether you're scaling a business, restructuring a team, developing a strategy, implementing change, conflict can arise, and it's how you deal with it that matters. So mediation, both as a process and as a skill, are very effective tools for de-escalating, managing and resolving conflict. And I certainly feel that, I suppose, business leaders are in a great position to raise awareness of and promote the use of mediation, not only as a settlement tool in litigated commercial disputes, but as a conflict management tool at all levels within businesses and organisations. So I prepared what I'm calling mediation mashups. So these case studies, and I'm going to take you through 3 case studies, have been inspired from a combination of different mediations that I've worked on over the years. And the reason I've mashed all of these cases up is to preserve confidentiality, which is obviously one of the important pillars of mediation that Graham's already touched upon. So I've been very creative with the parties' names, the facts, the outcomes, everything really. As I say, it's a real mashup. So the mediator's disclaimer, these case studies are completely true, except for the parts that are totally made up. So the first one, barefoot bust up. Sorry, just move on my slides. So this was a family business dispute. So the facts, a dispute had arisen between the Fraser family, who owned a film production company based in Glasgow, which we'll call Lomond Films Limited. Lomond Films made high-end, award-winning television programmes and feature films, and they were a major supplier to British, European and Australasian television networks. The company had been founded by the parents, Brian and Ellen, who wanted to retire and hand over the business to their children, Jamie and Janet. And the business was effectively the parents' retirement plan. Things started to go wrong when Jamie met a former Marine turned rewilding enthusiast and an environmental campaigner and aspiring TV personality called Claire Randall. And at that time, Miss Randall was in the process of planning a challenge to run a 1,200-mile off-road journey barefoot from Land's End to John O'Groats, and then to cycle the return leg. And the aim was to raise money for various environmental charities and to pursue her dream as becoming a reality TV personality. And Jamie was convinced this could be filmed for a documentary, but Janet wasn't on board. She viewed it as a very risky investment for the business, and they had no experience of reality TV or documentaries. And despite this, Jamie went ahead and commenced negotiations on a collaboration between Lomond Films and Ms. Randall for the production and distribution contract for a television docu-series. And that was following Ms. Randall's transition from barefoot running into road cycling, her training and the challenge itself. Janet found out, refused to agree to the collaboration, and the family fell out. The business solicitor, who can act for all family members in a conflict situation, suggested mediation as a way forward of resolving their differences out of court. So the mediation took place online over several weeks. Much to the parents' disappointment, Janet and Jamie were clear they couldn't work together. They had a very different vision about the direction of the business. They both wanted autonomy to pursue that, and they basically just didn't really like each other very much. So through the process of mediation, various options were explored by way of an agenda building session. So that was all the family members together with me working out all the things they needed to resolve to get an agreement. So how they would deal with staff, assets, debt, contract, plan for mum and dad. And at the end of that session, the family had agreed on 4 potential routes to settlement and a list of things they needed advice on to achieve that. So valuation advice, accounting advice, tax advice, and a plan for a joint approach for bank approval. Following that first session, it became clear very quickly the preferred resolution for Jamie and Janet was to divide the business into 2, and the mediation reconvened several weeks later once the necessary professional advice had been obtained, and the negotiation took place, the end of which the family had agreed and signed heads of terms, which was conditional on bank approval, and which they then took to solicitors to implement. So the solution was the siblings negotiated a division of the two companies, with one focusing on production and the other focusing on post-production, distribution and off-network syndication. One sibling was getting more assets and therefore took on more debt. An agreement was reached in respect of the parents' retirement by allowing them to remain in the business as silent partners in the most tax-efficient way. The lessons. So, this case study highlights the flexibility of mediation. A lot of the stuff that I work on is commercial claims, and I'll give an example of that at the end, where lawyers are instructed, the mediation is set for 1 day, but it doesn't have to be that way. So the mediator will work with the parties to design the right process for that particular dispute. It highlights that lawyers don't need to participate in a mediation process. I am a former lawyer, so I've got no issue with lawyers at all, and they often do attend mediations, but it doesn't have to be that way. And this case demonstrated that one mediator who's on everyone's side and working with everybody to get a resolution is a much more cost-effective way of negotiating than all parties instructing. So this case would have had 3 or 4 sets of lawyers to deal with the negotiation if the parties hadn't agreed that they wanted to come to mediation, they didn't want to go to court, and they wanted to try and work together with a mediator to resolve their dispute. So the second example, textile tussle. So this dispute, the facts. A dispute had arisen between 2 employees working in a weaving mill in the north of Scotland. So the mill offered design, consultancy and production services and was well known internationally by fashion designers who used only the highest quality wool and wool blend fabrics. So it was well known for designers who created unique, timeless and contemporary clothing. The dispute was between Elsie Campbell, the head designer, and Annabelle Mackenzie, one of the weavers, and Miss Campbell was the line manager for Miss Mackenzie. Miss Campbell had made a complaint about Miss Mackenzie and a disciplinary process ensued. Miss Mackenzie was found to have acted inappropriately in respect of accepting a gift from a supplier, and she hadn't notified the business about that. And the outcome of the disciplinary was that a written warning had been placed on her HR file. Miss Mackenzie felt she'd been unfairly treated. She felt deeply betrayed by her line manager, who she had considered a friend. And so following the disciplinary process, Ms. Mackenzie raised a complaint against Miss Campbell under the company's grievance procedure. However, that complaint was dismissed. This is a really typical example of a lot of disputes. Graham's touched upon this as well, a lot of disputes that businesses face and that I see as a mediator. The traditional disciplinary and grievance processes adopted by the business had only served to escalate the dispute, and the employer, the business, was at risk of losing one or both employees at significant cost. They were both very experienced, highly regarded employees, and the recruitment process alone would have been high. The mill was also in a small community. The dispute had created divisions within the wider workforce. There were concerns around recruitment and retention of staff in a wider sense. And there was also a reputational concern that knowledge of the dispute would become known in the wider marketplace. So the company wanted to retain both employees and give them an opportunity to repair their working relationship. So a 1-day mediation took place. Now, this example is slightly different because often workplace disputes will be between only the 2 parties to the dispute, so the line manager and the employee. What was slightly different about this dispute was it also involved the employer. So we had a 3-party mediation. And the solution was that an agreed plan of action was reached between Ms. Campbell and Ms. Mackenzie, which set out certain steps and commitments that they made to each other to restore their working relationship. The company agreed to revoke the disciplinary decision and remove the written warning from Ms. Mackenzie's HR file, and a joint statement was issued by all 3 parties to the workforce to sort of de-escalate the conflict in a wider sense. And I'm going to read to you some anonymous feedback for a dispute similar to this. So the feedback, this process has highlighted the value of engaging in mediation and working towards a resolution, even where it felt the working relationship was completely broken. Mediation provided me with the protected space to reflect and unblock painful and negative thoughts and thinking patterns and begin to see a way forward in a solution-focused way. In a wider organisational context, it has demonstrated that it's a powerful and meaningful approach with benefits that outweigh the outcomes that can be achieved when traditional disciplinary and grievance processes are applied. The lessons. It's never too late to mediate, to attempt to restore a working relationship. In an ideal world, it's absolutely better, where possible, to mediate before you go through those disciplinary and grievance procedures. But if that's not possible, it's not too late to mediate. Mediation is a great way to resolve multi-party disputes and bring in different parties with different or competing interests and get them all round one table to try and resolve all of the issues that exist between them. And in this case, as is the case in many disputes like this, and as Graham touched upon, the resolution saved the business considerable sums of money in recruitment fees and potential reputational damage as well. Shareholder showdown is the last one. So, the facts. So this was a dispute between 3 co-directors and shareholders, Susan Atwell, Tom Farrell and Ray Kinsella, and they'd entered into a business relationship. Their agreement was never properly documented and everything was based on verbal agreements, trust and confidence. Mr. Farrell was a gaming developer and he'd identified a gap in the market targeting female consumers between the ages of 14 and 21. He'd created a number of online gaming platforms, gaming apps, video games, such as Dragons of Pearl and Warrior Wish. Mr. Farrell and Mr. Kinsella were friends. They'd worked together on and off over a number of years. Whilst they both had experience of running companies, they'd never been particularly successful and had lacked any expertise to commercialise their ideas. Whereas Ms. Atwell ran her own consultancy business, she had significant experience in facilitating investment for startup businesses, both in the UK and further afield, and she typically charged a consultancy fee of $15,000 per month. However, she saw huge potential in the project and she agreed to work with Mr. Farrell and Mr. Kinsella on the understanding that she'd be a director and get an equal share in the equity of the company. So they all worked on this for over a year. They developed a business plan. They were working on pre-seed and seed funding. They referred to themselves as joint founders and they were all working to get the business off the ground. They each invested into the business, agreed to cover their own expenses, and they would later recoup that as salary after the seed funding round. Ms. Atwell had significant experience dealing with lawyers, so she became responsible for working with the company lawyers to put in place the documentation needed for seed funding for the new adventure. And the company Aptitude was finally incorporated in the UK, and each of the founders was appointed director and equal shareholder. However, the relationship began to break down. Ms. Atwell was becoming increasingly frustrated with the lack of documentation regarding what they had agreed. She wanted things recorded in writing. She wanted employment contracts, shareholders' agreements. She wanted their roles and responsibilities to be clearly defined and clarified. So eventually, shareholders' agreements and contracts of employment were drafted and they were negotiated, but they were never actually signed. And those contained various restrictive covenants and clauses in respect of intellectual property, confidential information and work product. After the seed funding round was launched, Mr. Farrell and Mr. Kinsella advised Ms. Atwell they no longer wanted to work with her and they effectively blocked her from the company, removed her from bank accounts, company's house, websites, marketing materials, that sort of thing. Within 6 months, she was working with a competitor and she was sued by Aptitude for £250,000 for unlawful or alleged unlawful use of intellectual property rights, confidential information, including information contained in the brochures and seed documentation, and for breach of the restrictive covenants in the unsigned but agreed contracts of employment. and she counterclaimed for unpaid consultancy fees of £144,000. Again, a really typical example of a sort of claim that I see as between businesses and founders and directors. So the mediation, so this was a commercial claim and a counterclaim. And so, as is typical for these sorts of disputes, a one-day mediation took place pre-litigation, but after pre-action correspondence with solicitors present. Now, this is where I'm going to ask for the audience participation. So, what sort of solutions might the parties have come up with? If anybody wants to be bold enough to give some thoughts, and you can put it in the chat if you don't want to speak. Sorry, Catherine, messing up your system here.
Not at all, Rachel. I'll keep an eye out for hands going up, people that would like to come in and offer some suggestions.
This is the joy of creativity and mediation.
I've got a thought. Can I jump in?
Yeah, of course.
Yeah.
Well, naturally, being a coach, you know, what I found to be very powerful are good questions, and actually, just the use of incisive questions to really understand, you know, the whole kind of Stephen Covey, you know, first seek to understand, then be understood. So I'd be going in with lots of questions with regards to really understanding what the underlying issues are, and then once you've done that, and everyone's got to a place where they feel like they've shared their piece, then you can start putting in recommendations and thoughts that are kind of win-win solutions.
Absolutely. Thank you, Simon. And you're right. So one of the things that Graham talked about in terms of the mediation process, and one of the things, one stage of a mediation process is option generation. So I always say to parties in mediation in advance of the day, cast a wide net, come to mediation and have thought of lots of different ways that might resolve this, that meet your interests and meet the other party's interests as well. And that's one of the stages of the processes where we discuss potential resolutions. So I'll don't know if anybody else has got anything to add before I can't find the chat now. Sorry, I can't see it.
I can't see anything in the
That's
chat,
fine.
Rachel, and
No.
nobody's got their hand up. Everybody's just stunned by the examples, which really bring it to life. I have to say, it really helps illustrate just some of the possible scenarios and situations that people could find themselves in or part of.
Yeah, well, I mean, I'll give you some, some ideas here. There could be a monetary settlement. There's obviously claims and counterclaims. When you see this in real life mediations, there can be payments one way, payments the other way, payments that, sums of money that cancel each other out. But there's an opportunity to have some creative thinking when it comes to mediation, because as is one of the lessons of this case, the parties are free to come up with whatever solution works for them. They're not limited by the legal remedies in the same way as a court would be limited by the legal remedies. So there might be a monetary settlement. They might agree to give equity in a company. They're both startup businesses. They might agree, I'll give you some equity in my business, I'll take some equity in yours. They might agree that they can work together. They might actually realise that although they've taken this initial response of how dare you go and work for a competitor company, there might be an opportunity for those companies to work together. So an analogy I often use when I talk about mediation is two children fighting over an orange. You go to court, the court says, well, one child gets the orange and one doesn't. There's a winner and there's a loser. If you take a sort of unsophisticated approach, you might say, well, we'll just cut the orange in two and each child gets half. But actually, through the process of negotiation, mediation, working out needs and interests, you might discover that one child wanted the orange segments and one child wanted the orange peel. So even where there can be these conflicting positions, often what underlies those are actually not conflicting interests. And I think that's what's really helpful about the mediation process. So this is obviously a totally made up example based and inspired from other mediations I've worked on. So I'll not give you a solution for this one. I'll just leave you thinking about all of the different creative ways that you might be able to come up with to resolve that. So the lessons from this is a claim and a counterclaim that were settled by way of a legally binding settlement agreement. And that's usually the case where you've got a commercial mediation and you've got lawyers instructed, and the settlement agreement is usually drafted at the mediation and signed off at the end of the mediation on that day. It saved significant sums in legal costs, wasted expenditure, management time and distraction from other priorities, which is what you always hear from parties to a dispute. Disputes often start out as a matter of principle, and 2 years into litigation, everybody's questioning why they ever ended up going down this road, because of the unquantifiable cost to a business in running a litigation. And as I've said, it allows for creative outcomes and solutions that could never have been granted by a court. And that's me, hopefully within my time. Thank you.
Thank you so much, Rachel. I'm now going to be that person that says, for the quality of the recording, I'm just going to pick up some of the conversations that have been taking place in the chat, because Marianne, you were first out the tracks with a really good question around how you can, now let me just find it again, how you can use mediation alongside a formal grievance process. And Graham, you've come back and said rather helpfully that sometimes organisations or businesses will build in a policy alongside their formal grievance process. I just wondered if you had any examples of that, or could just provide a bit more information on it.
Sure. There's I'm trying to remember the name of the organisation. There's an organisation down south which is led by a guy called David Liddell called TCM. And David's done a lot of work with the big corporates in developing an alternative to your traditional grievance policy, which they call a resolution policy. And it allows for issues to be raised. It allows for those to be dealt with. But part of it at the early stage is a built-in commitment to mediate, to have those exploratory discussions. And I know a number of the companies that they work with. I mean, another one I know from an example, one of our team may set up the Department of Work and Pensions in-house bullying and harassment unit. And they set up a mediation program across the whole of the DWP, which incorporated that, which allowed for those cases to be considered for mediation, and often there was a resolution. May's reflection on it was that often the person who'd been accused of bullying and harassment had absolutely no idea that their behaviours were being received in the way that they were, and that being able to have a conversation about that in many of those cases was really positive in being able to resolve those disputes and allowing people to A, have better relationships, and then B, to be able to move on as well.
Thanks, Graham. That's really helpful, certainly for my understanding. Marianne, I do not want to put you on the spot, but does that answer your question? Is there anything supplementary you'd like to come in with?
No, that's really helpful. Thanks very much, Graham, and thank you to you and Rachel.
Can I quickly just add to that? Sorry, because I saw that question from Marianne. I was going to also mention David Liddell. David's got 2 really good books. I've only read one of them. The first one's called Managing Conflict. The second one's called Transformational Culture, so the first one's more focused on workplace. Oh, yeah, there we go. Which one is that? The Managing Conflict one, or is it
Transformational Culture?
It was a bit blurry there. There are some resources online. I think there is a draft resolution policy made available at somewhere. You maybe need to dig around for it. But I think the only thing I would highlight here for organisations, and we have to think about how they do this. For example, the post office scandal, as we all know about at the moment, had a mediation policy in place a while back, and the mediators were post office staff. So I think when you're looking at having a mediation system in place for organisations, you have to think carefully about who the mediators are going to be, and should they be external, independent, fully independent mediators, or should they be internal? And you just need to think about that when you're looking at how you work these things.
Yeah, it's really helpful. Thank you. Yeah, I suppose it's kind of balancing it. So I'm an employment solicitor, so that's kind of where I'm approaching it from, and it's balancing it with, the point, Graham, that you were making of sometimes people who are making bullying and harassment claims aren't aware that that's how they're being interpreted. but that doesn't necessarily protect them from the law of it, and that it could lead to a gross misconduct, or should lead to a gross misconduct, and I suppose it's balancing that between dealing with that and dealing with it and the seriousness of the incident, alongside looking to try and resolve the issue from a wider scale. And I suppose maybe as a first step, that might be a good step, but that you may need to, if it's if someone's gone through mediation and they're a repeat offender, then it's obviously not working and changing their discriminatory or bullying views, perhaps. So I think I can really see the benefit, and I've been involved in judicial mediations myself in the employment tribunal, which have had some good, some bad results from them. So I really see the benefit of it, particularly in a litigious process. I think it's really beneficial.
Yeah.
We had Joe Dinverno speak.
I'll have a look at David's things and kind of look at the resolution policy, because I do certainly think for some clients that would be a really good thing to introduce.
I've heard Joe Dinverno speak, and he's one of the tribunal judges that does mediation. And I just couldn't get away from thinking how interesting the dynamic would be of a judge mediating when they're reality testing with the clients on what might a judge think of this. Just in terms of the way that they would process it. But
the judge isn't so it's not the judge who would hear the case.
No, it's just.
But you do very much think that there's a kind of sense check taking place, and a reality check for all parties of not reaching the mediation. And although it's not that judge who will hear the case, judges are judges, and they've kind of come from the same approach generally. So it's a good kind of testing the water almost. And for a lot of clients, and I've been in mediations for claimants and respondents, it's a kind of stark insight into what it is to be in an employment tribunal in a much gentler way. And if they don't like the mediation process, the reality of a tribunal hearing is going to be a bit of a shock. Sorry, I feel like I'm hogging the conversation. Thank you.
Thank you.
I'm going to, Barbara, bring in your comment, if that's okay as well, because I thought that was a really interesting point to make in the chat. So Barbara was saying, in her experience, it's about kind of thinking about communication and perhaps that prevention is better than cure, as opposed to looking at conflict being inevitable. Again, Rachel and Graham, I know Graham, you came back in the chat, but just would be keen to kind of maybe get a bit of a discussion going around that point. And Barbara, if you wanted to come in and add anything supplementary or additional, please feel free to do so.
Yeah, I'm sorry. Well, I'm just reading.
Thank you. Thank you, Catherine. Yeah. The first comment I made was that I'm a master practitioner in neurolinguistic programming, and there you get to question all your beliefs, and that's just what snagged for me, because some people might wonder at this, but I really don't like conflict, and I would much rather have cooperation and collaboration. So I tend to use that as a filter, and try and set up arrangements with people that are collaborative and so on, so less likely to run into disputes. I understand that can also be an excuse for me and others to give in, and then that can just lead to resentment and other problems and so on. So there's a balance, I think. Yeah, that's what I'd say.
So
I thought I was going to say, I thought it was a good point that Barbara had made on that one, because it's actually one of the things that we often talk about is that actually sometimes conflict can be positive, because sometimes if used creatively and with the right protection, it can then allow for positive change to take place. It's sometimes uncomfortable for those who are involved, but sometimes for some organizations, they need to go through a bit of something to get to somewhere else. But I do utterly agree with you about the skills piece and communication, because so many stuff that come to mediation is as a result of poor communication. One of the things that I I've always said about personally is I did my mediation qualification 12 years ago. I'd spent 20 odd years managing students' unions and other organisations prior to doing this, and I so wished I'd done that training for those jobs. Not to be a mediator in those jobs, but just to understand the dynamics of what was happening in terms of conversations, reading people, being able to ask the right questions, and just different thinking. And it's probably similar to what you're saying, Barbara, about your NLP stuff. It gives you an awareness of what's happening in the room. Sorry, I cut across you, Rachel. You were going to say something.
No, and thank you for your comments, Barbara. I don't have any specific expertise in NLP. I've done a course a course on asking questions, Jerry O'Sullivan's course, and she has a whole chapter in her training and her book around NLP inspired questions that mediators can use when they're dealing with things. So yeah, no, I absolutely agree that prevention is better than cure. And I think where conflict arises, if you can deal with that at an earlier stage because the longer it goes on, it's the sort of I can't remember, there's sort of nine stages of conflict. And the last one is, falling into the abyss. And basically, it takes you through something that Jerry O'Sullivan refers to in her training. And the more it goes on, human nature is the more we have the various psychological biases, the confirmation bias, where we focus only on our version of events, our positions, and we ignore how other people see it. And it's just the way the human brain works. And from its sort of, you can learn skills and you can train yourself to think in different ways, but most people, unless you work in a profession where that is something that you come across, most or a lot of people don't have that knowledge, and why would they? So people become entrenched in their positions, and the longer that goes on, the harder it is to resolve, unless you've got a commercial claim, a litigated case, and you've got a claim for 100,000, but it's going to cost you 150,000 in legal fees, for example. And that sometimes can focus the mind around what the alternatives are, and using your alternatives as a benchmark to consider whether you're going to do a deal or not. And that's the more sort of commercial side of mediation. But I definitely agree with what you're saying, Barbara.
Well, in the absence of any other questions, this is your 1 minute warning. I can waffle for about a minute, but then that's about us. I just wanted to say, this has been hugely informative, and I opened by saying, kind of conflict is something that we are having members get in touch with us about, and ways to resolve that. And I think it's something that I certainly am keen to learn more about, and look at how I can be a bit more kind of proactive and supportive and helpful in that space. So I'm going to go away and have a look at doing some mediation training myself. Thank you, Graham and Rachel, both for a hugely informative discussion. I think just the case studies that you had, Rachel, really brought it to life for me, and Graham, in terms of kind of scene setting and just explaining what we mean by conflict and the various different ways that mediation might be useful. I know certainly I hadn't considered a lot of it. So very grateful to you both for giving up your time, and of course all of you who have joined in, and I hope you all take something away from the session today. We have recorded it, and we will share a link to the recording, because there are a number of people who weren't able to join us live, and I'm really pleased that we're going to have such a quality recording that we can share. So thank you everybody very much, and I look forward to catching up with you all soon.
Thank you.
Thank you. Take care.